Good afternoon, everyone. I am Stacy Price, and I serve as the on the FSBPT Board of Directors in the administrative seat. And I'd like to welcome you all to the Regulatory Hour. Those of you who have joined Dale Atkinson in his regulatory hours previously, you know you're in for a treat. And I can't wait for those of you who have not joined before to just see just how much information that you gain by participating in today's event. Whereas we want you to sit, listen, and enjoy what you are learning, we also want you to be ready to engage with Dale as he speaks about today's topic, which is what makes regulators tick, and that's statutes, regulations, and policy confirmations. So sit back and enjoy, and I will turn it over to Dale.
Well, welcome everyone. And how's my sound? Somebody give me a thumbs up. You can hear me? Excellent. You can see the screen, I hope, as well. And Stacy, thank you for that introduction. And everybody now lower your expectations after after she says all that. So, but welcome. And let me begin like I always begin all my presentations for all my clients, and that is by saying thank you, a big sincere thanks. So thank you to FSBPT and its leadership for having these and actually allowing me to be a part of your family and putting on these regulatory hours. Thank you to the staff for all the work that they do to make this happen. And the biggest thanks goes to each and every one of you who are on the line today. You are in a thankless job of being a regulator, whether you're a board member, administrator, executive director, investigator, staff, assistant AG, whatever role you play. It's really a thankless job somewhat, but it should be self-satisfying to you. And so a big thanks goes out to you. You're not thanked enough, but I will thank you. So if we can slides to move on. So again, welcome. As mentioned, my name is Dale Atkinson. I'm an attorney in private practice, and I represent a whole bunch of FSBPT like groups. And the only reason I'll stay on this topic for just a minute or two is to make sure to let you know that you're not alone as a regulator. So again, no matter what role you're in, you have each other to learn by. You have lists of participants in these types of regulatory hours. Take advantage of that. You have your meetings with FSBPT, and you can learn from each other. And so these kinds of contacts can be extremely important, and there are cross-profession contacts. So there are a lot of other FSBPT-like organizations. So take advantage of your time together. Take advantage of presenters. Take advantage of the staff and the board of directors to learn from each other. Find out those best practices and what's working and perhaps not working as well. So I encourage you to do that. But today's topic is what makes regulators tick. And I find it interesting how we can spell tick different ways. And of course, everybody probably is familiar with TikTok. As is tradition on this regulatory hour, which we're doing monthly, you get to pick something that might identify how you feel today. And it doesn't need to correspond with the status that's laid on here. But if anybody wants to just practice your chat and go ahead and chat in what you feel like today. You could be a CEO right on through to a faking sick leave employee. So it's nice for me to know, one, you're engaged, you know how to use the chat feature, and two is that you really tell us how you feel today. So I think we have a couple of faking sick leave. We have some new hires, a seasoned employee. So we'll pay close attention to the seasoned employee so that we don't lose you during our sessions today. So again, this is to make sure that you're listening. One, and two is that you are, again, learning to interact with each other in this day and age of virtual communications like we are. So there's pros and cons to each of these, and it's great to be able to carry on and continue engaging with each and every one of you via the FSBPT. So again, as is tradition, I put up a picture of some famous person who may or may not be a lawyer. That's not really me, for the record, but I am, as mentioned, an attorney in private practice outside of Chicago, and have been doing representing FSBPT-like organizations for basically my entire career, which is going on 34 years. So hopefully some of the experiences will allow us to keep our engagement going and cover content that is relevant to each and every one of you who are on the line, again, regardless of your position. And then the last tradition that we have to get us going is it's always fair game to talk about hockey. You can unmute at any point in time, but I encourage you, by the way, to unmute. Encourage you to use the chat. We try to keep an eye on it, and Stacy will help me. So Stacy, if questions come up that I kind of don't see or blow past, feel free to interrupt me and just ask it. And we're good to go here. And there is a Bruins fan on here, so we're going to have to really hold it against this Bruins fan. But hockey is always fair game. And congratulations to the Tampa Bay Lightning for their recent Stanley Cup win, in spite of the fact it's 2 years in a row. And that's kind of boring, right? So, but we root for the Hawks, and there's some Blackhawk paraphernalia right behind me. So always fair game to do that. If you're not sure what to say, talk about hockey. All right, so my advancing is a little bit different. Okay, so to recap where we are, these are monthly as mentioned, and we started from, let's meet with a purpose. Why does regulation even exist? How do regulators meet their obligations? We're on a roll, your roles that you play and the different hats you wear. Together is better collective wisdom and the programs of FSBPT. Conflict zone, which is conflicts of interest. And this month, we're talking about what makes regulators tick. Next month, here comes the judge or top cases, followed by applications and renewals, followed by efficiency-driven issues, communication protocols, and we'll end up in December with a year in review. So that's where we've been and where we're heading. And it does somewhat build on itself, but I also try to ensure that if we have people who are on the line who haven't been on the line, that we go back to square one as necessary. So we'll keep that going. So the next chat for you all is to describe your first day with the board. And again, no matter what role, you could have been a staff person, you could be a governor-appointed board member, but what best describes your first day? So 1, you knew what you were doing. 2, you had no clue. 3, you thought you knew, but your experience verified what I thought I knew. Or 4, you thought you knew, but your perspective has now since changed. And 5, you knew you needed some training. So you can pick one of those. And I suppose some of you could pick as many as you want as well. And I see a couple of 2s that are coming up here. You had no clue, and I hear that a fair amount, and it's not unusual because the role you play as a regulator is very different from your role as let's assume you're a licensee for right now, or as the Supreme Court calls you, an active market participant. Your role as a licensee, as a practitioner, perhaps as part of the trade association, perhaps promoting the profession and all that, really has to be set aside when you take on a role of government. And so the reason that I bring this up, one is it's fundamental to a regulatory perspective, and 2 is it should form the foundation for what makes you tick, and that is assuring that you understand that role. And no one is going to come in knowing everything, and so the fact that you might be a 2 in there is not a big issue as well. So and some of you knew what you were doing. You may have served on other boards, or you may have had experiences that allowed you to come in knowing what you were doing from a regulatory perspective, but it's a mindset that you have to really learn to have. So it's important, I think, for us all to at least decide where were we when we came in, and where are we now. So let's just start with the basics. It's always a good place to start, even though what I'm about to say is so fundamental. We probably already know this, but questions do surface, and that is physical therapy boards are government. You are government entities. You are created by statutes. You are creatures of statute, and you can only act within the parameters of what that statute authorizes you to do. And as creatures of government, there are all sorts of rights and obligations that arise out of the involvement of government. And we're going to get into those in a few slides. But the point being is that we're dealing with a situation where government issues a credential, a license, and it is mandatory that I have that license. And if I don't get that license and I engage in activities that are within that scope of practice, I can get in trouble. I can get in criminal trouble, let alone potentially administrative trouble or even civil trouble. So the point of all this is when government becomes involved, we have to understand that there is an element of how government acts and the requirements around that, as opposed to FSBPT, which is a private organization. It does not have to live by the same rules as government. And it does generally to some degree, but at the same time, it does have certain rights that it can maintain, either confidentiality and other means, which physical therapy boards as government operate in the open. They are transparent, but for some relatively limited exceptions. So the basics are you are sitting in a role as government and you need to act that way. Okay. And now as an individual board member and collectively as a board, you act in the interest of the public. Everybody thinks they know that. Great, fine. And does it always surface and is it always front and center in the decision-making and discussion process of your boards? You can ask yourself that question. And do you do it? And does your fellow board member and staff and others as a group undertake that? But it's always good to step back and remind ourselves why boards even exist and why government exists. And that is to maintain order, number one, but it is also to operate in the interest of the public as a whole. And if that drives your decision-making, then that's a good thing. And that is what makes regulators tick. So physical therapy boards, all regulatory boards, derive their authority through a legislative delegation of authority process. Meaning, as I've already mentioned, legislation is enacted that creates and authorizes the board, okay, your board. It delegates authority to your board to act in a government capacity and enforce the Practice Act in the interest of public protection. And we should all be able to articulate that. And we've talked about that all the way back to the very first session this year when we dealt with government and the purpose and the big picture of why. So it's a delegation of authority. That's a legal doctrine that allows you to act on behalf of the public as a whole in a licensure process. And we all know what important role you play. You determine whether someone gets a license and can practice, or perhaps someone is denied a license, or perhaps a licensee is subject to an adverse action. And all of those points now have created rights. And because you act under a delegation of authority principle, and because you act in the public interest, you are afforded certain protections through immunity and other doctrines that allow you to undertake your important responsibilities without threat of intimidation or litigation related to when something might go wrong. So keeping that in mind. So delegation of authority is where we'll spend a little bit of time today to ensure that we are all understanding of the basic foundation. So delegation of authority does occur legislature to the board. The statute, as I've mentioned, it creates and authorizes you to act. It sets the board, it provides duties, responsibilities, obligations, powers, if you will, of that board itself. All of this is going to be set forth in the statute. How many people serve, how long you serve, the qualifications to serve, licensee members, public members, and any other categories that might exist, including right on down to geographic locations, scopes of practice, practice areas, academic versus otherwise. And you see a whole host of these legislative enactments that create regulatory boards like physical therapy boards. So that's all done via statute. That's a delegation of authority to you as a board to act. The board can delegate to a private entity, and we're going to go through some examples in the Model Act in just a few minutes, but the board can designate to a private entity through rule or regulation. You promulgate a rule that says we recognize the FSBPT examination program because we know it is a valid measure of entry-level competence, and it promotes uniformity, and it saves us as each board at each state a whole lot of money from having to develop and validate our own test, and it provides insurance to us in the event of a challenge. So somehow all of these things come together, and your board says, through the promulgation of regs, we will recognize that exam program. And I think maybe I didn't say this, but it promotes uniformity and licensure mobility and portability and all the things that are quite front and center right now on a lot of politicians' minds. And then lastly, and there are other options here, but lastly, the board can delegate to staff. So in other words, in between board meetings, what can the staff do? And perhaps what can the staff not do? Renew licenses, issue an initial licensure if there are no red flags in the application, or anything else that you might think of for purposes of an efficient system that allows the licensure process to move forward without slowing it down unnecessarily. And I think everybody on the line today probably knows and understands that regulation is under challenge. That's not necessarily a bad thing, by the way. And to turn the lens back on yourselves and figure out how efficient are we, we're going to talk about that in just a couple of months as part of our specific topic. But these are all issues, this delegation issue from legislature right on through board to the staff is designed to create an efficient system. And I think we all know that's why boards are populated with licensees, with active market participants, because it brings expertise to the table. And it allows that board then to function in an efficient manner, as opposed to a civil system or even a criminal system, whereby you don't have your juries and decision makers who have all the expertise necessary to make such, important decisions about whatever scope of practice or anything else. So this delegation of authority is really important. And as we come back to our topic of what makes you tick, you all have to understand that this is what makes you tick, a legislative enactment that creates you. So let's make sure that we now understand the differences between statutes, rules, and policies. So statutes enacted by the legislature, they have force of law. Force of law meaning if I don't follow them, I can get roughed up. I can get in trouble. I come from Chicago, so I can say roughed up, by the way. So if I don't follow them, bad things can happen to me, likely in a criminal setting and beyond. Rules and regs are promulgated by your boards using the expertise we just talked about. And by the way, when I emphasize the expertise on boards, this is not to not include public members who play an extremely important role from a mindset and a perspective. So while I probably emphasize licensees who serve on boards, this is not, again, ignoring the importance of public members. Licensees on boards are what get boards into trouble more often, perhaps, than public members, just because of a mindset issue and a professional promotion issue. Just ask the North Carolina State Board of Dental Examiners that question. And that is what really, I think, drove some of those decisions. But so rules and regulations are promulgated by the board. They have force of law, meaning that once they are duly promulgated, they are enforced. And if I run afoul of the rules or regs, whatever you call them, and in some jurisdictions it actually uses both, I'm not sure why, but that does happen. If I run afoul of them, again, you can rough up my license. I might be subject to an adverse action and a removal of my right to practice my chosen profession. So these are extremely important. And that's why the rule process is what it is. It follows where you notice things up, you take comments, you may have hearings, you may modify, renotice it up, have hearings ultimately before that rule is promulgated into law, if you will. And then the last thing is policies. Policies are operational driven. They have no force of law. They're adopted by the board and they can be changed at every board meeting if you choose to do that. And so it's probably not a good policy to do that, but you should have some policies that address some of these operational driven issues. And we'll come up with a few examples in a minute, so on some of that. So I'm trying to keep an eye on the chats here as well. So any comments or questions so far? Statutes, rules, policies that will form the basis for some of the things that we are about to talk about. So I wanted to lay a little foundation for that. So now using the Model Act, which, by the way, most all of my clients have a Model Act. Your guys, my printed version looks like this. And take advantage of the Model Act. I can say this, I think, with some credibility, and that is Model Acts that are developed by and adopted eventually by my clients sometimes sit on the shelf too much. They really serve an important purpose to determine the collective wisdom of a group like FSBPT and all the people that went into drafting and amending your Model Act as to the so-called best practices of legislation. And so as legislators are looking to modify, amend, repeal legislation, you all, as regulators who have hopefully forged relationships with the legislature, not necessarily lobbied, but you're an information source, can turn to a Model Act like this and use it for the benefits that you see fit and as appropriate. So let's get back to one is what makes regulators tick. And probably the most important section of the Model Act is this one. It's Article 1, it's 1.01 legislative intent. And apologies, but I'm going to read this because it is that important. So this act is enacted for the purpose of protecting the public health, safety, and welfare. So remember now, this is suggested statutory language. So if this were actually enacted into law by your jurisdiction, I would be reading the intent of the legislature. And that is extremely important for a whole lot of reasons, which we're going to get to in just a minute. So let's keep reading. It provides for jurisdiction, administrative control, supervision, licensure, and regulation of the practice of physical therapy. So this is a very clear statement about public protection and regulation. This is extremely important in today's day and age and post North Carolina State Board of Dental Examiners case, which I hope everybody on the line knows what that's about. But in general, it was an antitrust case, allegations against the North Carolina State Board of Dental Examiners, which went to the U.S. Supreme Court. And the Supreme Court basically, it was an immunity question about immunity under the antitrust laws. And the Supreme Court decided that there was no immunity, but for certain circumstances. So, and that circumstances is a clear intent stated by the legislature. That's what this is right here. And then sufficient oversight by government over the regulatory board itself. And that second prong, that oversight issue, is where all the angst developed and where there was a lot of reaction and, in my opinion, overreaction. But be that as it may, this clause right here is important. And I'm guessing, and with all the legislation I've read from many of my members of my clients, a lot of your practice acts do not have this legislative intent. So if we keep reading, it is the legislature's intent that only individuals who meet and maintain prescribed standards of competence and conduct may engage in the practice of physical therapy. Again, a very important statement to make, which dictates why you tick as a regulator to say we intend to ensure that only those who are competent can practice. And what does that mean? Some people will deem to be unable to practice because they don't have the competence. And we all know about the 3 E's, education, examination, experience, that may exist as part of the licensure eligibility determination that's made. There's maybe good moral character, criminal background checks, file an application, pay a fee. There's other things there, but this competence-driven issue is established through the examination program. And everybody on the line should be able to distinguish between the education and the examination program. Okay, so topic for another day, but so if we keep reading here, the last sentence of this clause, this act shall be liberally construed to promote the public interest and to accomplish the purpose stated herein. This is probably the most important sentence in any practice act, is this liberal construction, because what that means is when there is a challenge to the legislation, and let's say there's some ambiguous language within the laws, which there is ambiguous language in all the practice acts. And it might be something along the lines of unprofessional conduct. That's not subject to being defined. It's unfair to enforce it against me. It violates some constitutional principles of due process and otherwise. All those challenges, by the way, have failed, but they're made relatively regularly. Right here, this liberal construction is telling the judicial system when there's a challenge, you liberally construe the language of the act itself. Super important. This is what makes regulators tick. This is what is, again, the driving force behind a regulatory structure that is intended to protect the public and recognize the fact that not everybody is going to gain that eligibility and ultimate licensure to practice whatever their profession might be. Obviously, in your case, physical therapy. So it is really worth reading your practice acts, as boring as they might be, and as hard as they might be to read. You all should read them, no matter what role you play, and have some basic understanding. But hopefully it's regulatory hours like this that will make certain language jump off the page at you when you do read your act. And you as a board then, and an individual board member or staff administrator, you will be much better prepared to address legislative issues when they do come up. And I am naive enough to think that the legislatures at some point in time in the future, anytime there is a suggested amendment to the Practice Act, that it automatically goes to your board to say, we're thinking about doing this. Is this a good idea? Are we missing something? They ask for you all to weigh in on that and forge those relationships so that can happen. And that can happen, by the way, in a process that is not considered lobbying, which can get a little bit dicey here. But the point being is this communication is super important. So read your Practice Act. Words will jump off the page at you. Continuing on your Practice Act, now the Model Act of FSBPT, under Section 2.02, the powers and duties of the board, I've highlighted and underlined the word shall. okay? So what does shall mean versus may versus must or others? So again, as you read your Practice Act and determine what makes you tick as a regulator, which is going to be this, you will, again, start to identify these important kinds of terms and phrases that exist. So under 2.02 subsection 2, that you shall, as a board, provide for the examination of physical therapists and physical therapist assistants. So right here is a great example of a delegation of authority from legislature to the board itself. And then what the legislature is recognizing, that board, use your expertise and promulgate a regulation that provides an examination program that assures validity and defensibility, and then ultimate entry-level competence determiners as one component of the licensure eligibility. This is a perfect example of delegation, legislature to board, and it doesn't say what exam here because the legislatures don't know anything about exams. And the legislature should never deal, in my opinion, should never deal with issues of content of exams. Exams must cover certain content areas. Oh, and some legislators actually enact into statutes scores. You must pass it with a 75, and nobody knows what that 75 is. And when you talk about scaled scores and cut scores, those numbers are actually irrelevant. And again, everybody on the line today should understand that an entry-level competence exam like FSBPT's determines entry-level competence, and how far above that cut score that you score is irrelevant. It's a determining point of competence versus not competence used in the licensure process. And so it is a criterion referenced exam that everyone can pass or everyone can fail, and it's going to be determined on my ability to demonstrate that competence. So the point is here, this is a great example of delegation to the board to determine. And as you can see there, I put in red there, you go to the definitions of exams under 1.02 subsection 13, and that is in your Model Act. I did not reproduce it in a slide here, but it does say exam means a national exam approved by the board for licensure of a physical therapist or a physical therapy assistant. It's got some certification language in there as well, depending upon the terms you use. But again, that's a good example of these delegation principles. This is exactly what makes you all tick. Section 3.02 of the Model Act, qualifications for licensure. An applicant for licensure as a physical therapist shall pass an exam approved by the board. Once again, this is legislative delegation showing that the exam must be passed, and that passing point is going to be determined through a process of your state board recognizing the exam owner, FSBPT, and having faith in the process. Now, one more thing, since I'm kind of emphasize this point a lot, is to distinguish between private sector groups and FSBPT. The membership of FSBPT and all of my clients, just like FSBPT, is limited to the state boards, the governmental boards. They're not trade associations. They don't promote the professions or anything else. And the fact that FSBPT is the membership is comprised of state boards, of government entities, distinguishes from any other organization that might exist. So if another group came along and said, we're going to develop an exam program, we're in the private sector, we're a for-profit, whatever else, that's a very important distinguishing factor from an organization whose membership are comprised of the boards themselves. And I say that just so you hear it, because there are some legal nuances that would assist in doing that. So in distinguishing and making legal arguments that support certain legal doctrines. So physical therapy boards are delegated with the authority to promulgate rules and regs. We've already talked about that a little bit. And so I'm back to 2.02, powers and duties of the board. The board shall, 6, adopt and revise rules consistent with this act. Such rules, when lawfully adopted, shall have the effect of law. And that's what we've already talked about. Statutes have force of law. Rules and regs have force of law. Meaning, if I don't comply, I might get in trouble, right? Now, 2.02, read that top sentence again. The board shall adopt and revise rules. I see many cases, maybe not many, but I see quite a few cases whereby language like this is in a state law and the board fails to promulgate rules. Okay. Now, under that number 6, if I were editing your model act, I would use the word promulgate, but adopt, either way. But if you are told to promulgate rules by the legislature, you should promulgate rules. So if it's an application process pursuant to rules promulgated by the board, it says that in the law, we'll promulgate some rules and talk about how it's going to work and figure all that out and then live by it. And that's only fair because that's what the rest of the world, if you will, needs to see, especially the applicants for licensure. So that shall can be very important. I will also say now on the heels of what I just said, that there are multiple cases where the court has said, well, shall really is permissive. They don't have to do it, but I wouldn't rely upon that under this kind of a circumstance. So if you're supposed to promulgate rules and set up systems that then support the activities of the board itself. If nothing more, it gives you the legal backing if there is a challenge to that process. So important concepts, important issues as to what makes you tick. Now, if you act outside of the authority granted to you by the legislature in that practice act itself, you might see something called an ultra vires act. And that just means that you acted beyond the scope of your authority as a board. And perhaps what you have done is now going to be undone. Okay. And we all know how that could be. That could be not only embarrassing and costly to your board, but it sets some political wheels in motion. It can do a lot of things that might try to rein in what is activities by the board determined by the legislature to be beyond that scope. Most of the cases that I see, and as part of my law practice, I follow as many administrative cases as possible, and we have a data bank of them, and there are a lot of them, believe it or not. But most of the cases around rulemaking is on this very issue here. Did the board have the authority to promulgate a rule? So for instance, if a rule is to expand the scope of practice. So the scope is defined like this, and you promulgate a rule that says, well, we can really do things like this. That is probably an ultra vires act. It's outside the scope of the authority of your board because only the legislature can identify that scope. Now, to distinguish, you can interpret that act to allow or disallow certain things, but you can't just overtly expand that scope. And there's a nuance in there, and it's a fine line at times. But most of the litigation, especially those that are successful, deal with this ultra vires question and whether the board even had the authority to do what it did do. So keep that in mind. So somebody type something in the chat, so I know you're all still listening to me. Okay. Oh, perfect example here. So chat the number applicable to your opinion. Once a board decision is made, what describes the role of a dissenting board member? So something came up, discussed, everything's all on the up and up. A vote is had and I vote against it, yet it passes. What is my role here? So one is able to publicly express that I voted against the motion. Two, unable to publicly express that I voted against the motion. Three, able to publicly speak out as to the content of the motion and my rationale for voting against it. And four, unable to speak to anything related to the motion. So y'all think about that and type these in. I see a few coming in, some ones and some twos. Okay. And I will admit that there needs to be some discussion behind your answers. I get it. So I'm forcing you to take a stand here of one versus the other. And I know you all probably want to speak more to it. So by the way, if anybody wants to unmute and speak to this issue, you can. If you want to talk about what may have happened with your boards and you want to remain anonymous, somehow we can figure that out as well. But if you want to bring up a hypothetical, that's okay. So I actually see a lot of different answers here. And let me scroll up and down quickly. So I do see some ones, some twos, some fours, some threes. So it seems to be a nice mix. I like it when we get these kinds of differing opinions because it's worthy of discussion then. And so somebody just wrote here, I believe it's one because the vote would be recorded in the minutes. And that's a really astute point. So back to my scenario now. I voted against it. And let's just quickly talk about how your minutes read. And so a motion came up and it passed 7-1. And does it say Dale, dissenting vote Dale, or Dale voted no, or something like that? You all can decide what your minutes are going to say, as opposed to unanimous, or as opposed to recusals and abstentions, as opposed to no votes. And there's no real easy answer to this question. However, the minutes might reflect that Dale voted no, and probably should reflect that Dale voted no. The question is, post-meeting, what can I do as that dissenting voter? And quite frankly, that's a communication protocol issue. That's a policy that it's a good example of a policy that should be adopted by your board that identifies how you communicate. Okay. And then we had a couple more messages chats came in. So you ought to have a policy that addresses this particular issue. And I would probably answer this. I would create a new answer, and I get to do that because I'm hosting this, I guess, or I'm the speaker. But and that would be, I would follow communication protocols. Okay, period. Now, most likely the communication protocols are number 4 for me. I'm unable to speak to it. If somebody came up to me, a reporter came up to me after, hey, I understand, I saw the minutes that you voted against that particular issue. You want to talk about it? The answer is no. The answer is no, and because the board speaks with one voice, and that's what the policy ought to say. And that one voice, by the way, is going to either be your chairperson or your administrator, executive director. Perhaps it might be both, but the point being is that you can't have your meeting ended, everybody walks away, and then you have 7 different people saying, I voted against it, I voted in favor. This is a great idea. This is a horrible idea. That will drive your board into dysfunction, potentially. It will also send messages to the community and the public as a whole that you may not want to send. So your communication protocols probably are going to point to 4 if you have them. And everybody lives with the decision, majority rules. And there's nothing wrong with that. And I realize that some of you may be now, twitching in your seats saying, I want to be able to talk about it. And you just can't. You speak with one voice, and that's group decision making. That's how that actually works. And your no vote can be placed in the minutes, and that's fine. So anyway, if anybody has any comments and wants to unmute and speak to that, I'm going to keep going, but we're happy to be able to engage in any dialogue or discussion about that. So we've already said this. Does your board have communication protocols, and do you comply? This is a question of, do you even have policies? Okay, and if you do, have you read them? Policies are equally as important to statutes and rules and regs, in my mind, because they're operational driven. And you confront those, if you will, confront maybe a bad word, you comply with those on a regular basis. And you, as you should, including an important question like communication protocols. And the media would love to separate board members and have them talk about certain matters and then write about it. That's what they like to do, good or bad, whatever you want to think about that. So the point being is that adopt some policies, okay? And somebody typed in your minutes should follow Robert's rules, reporting of results. And so, I'll ask you all, one is, do you follow Robert's rules? And if so, where does it say that? Probably, does it say it in the regs or in an Administrative Procedures Act? And I'm not saying it shouldn't. I'm not being critical of that. The point being is that gives order to your meetings. But Robert's rules is quite particular. And there are not a lot of people that know a whole lot about Robert's rules. And I serve as a parliamentarian for my clients. And I have Robert's rules close by because it's hard to sometimes figure out some complicated things that come up. But be that as it may, you want order to your meetings. So it does bring up a question. When you all vote on a motion, is it a voice vote? Do you take a roll call? Do you raise hands? And so, think about that. And I know many of the boards become a little more formal when it comes to voting on motions and always do a roll call. And that's another way to create minutes that assure that everybody votes and it's not just a yay or nay. And you think about it as the chair and say it passed, and you may not have accurately reflected maybe everybody's vote or something. So think about how you do that. So we've got a roll call always. And I think that's probably good policy. That's another good example of a policy of how that's going to work from an operational standpoint. And these policies then give direction to your staff, your administrator, executive director, and staff to assure that there is consistency from meeting to meeting until the policy might get changed if it needs to be changed. So it's entirely up to you all to figure that out. So communication protocols is a great example. So there's a whole bunch of nuts and bolts that we could talk about and that we kind of already have related to legislation, regs and rules and policies themselves. But I did want to leave a little bit of time to talk about why are you on the board as an individual. So we've got the nuts and bolts, we've got the formalities of the law and the technicalities of the law that exist. But individually, have you thought about that? Why are you on or involved with the board as either a staff person, a governor-appointed board member, or other? So ask yourself that question. Now, we all know that we have preconceived notions, okay? And we all are going to bring those to the table. But as a reminder, this is a government-driven system where a license is mandated, and failure to obtain that license can lead to bad things to someone who is engaged in the unlicensed practice. With that said, protections are built around the system. And at what point in time do your preconceived notions get in the way of that fairness or due process that is required of a government licensure system? So everybody can think about that while you were on that. So once you get appointed to that board, okay, and this could apply to staff as well, but probably more so to board members, it's a mindset change. This is how we started today's session, is to talk about how different it is to be a regulator than it is to be a licensee, than it is to be a trade association person, than it is to be a lobbyist who wants to effectuate change that creates financial incentives to the profession itself, or creates insurance reimbursement increases or recognition or anything else that is driven by trade and driven by improving, if you will, the financial or other means of the professional and profession itself. But it's a mindset change when you're involved in government, and your perspective has to change. And we've already talked about the need for expertise. And this is, again, not to not include public members, but again, we focus on the issues of licensees because that is where legal issues arise more often than not. So we all bring something to the table: knowledge, experience, expectations, bias, preconceived notions, or others. And the issue here is, can those be managed in a manner to assure that decision-making complies with fundamental fairness or due process? And if I haven't emphasized it enough, government's involved, it's mandated. The rights that are wrapped around that process are called due process. And due process for the non-lawyer, for the layperson, is just fairness. It's all you have to remember. Let the lawyers take it from there, and they will help you navigate these due process waters. Quick reminder, boards of government, I've already said this enough, but the rules are different for government than the private sector, so keep that in mind. So what does a mandated government licensure system trigger? I've mentioned that. There are rights that are built around this. Applicants, licensees, consumers, board members, staff, assistant AGs, there are all sorts of rights that protect the process, but related to the applicant and licensee, him or herself, is basically a due process of law question. Due process, as I've mentioned, is fairness. You will know it when you see it, most likely, but your lawyers are going to help you navigate this. But I want you all to have that basic fundamental understanding of due process. This is what makes Regulators Tic, is an understanding of these types of big picture principles so that you can ask the questions when they need to be asked. So if you don't see an issue, you'll never get to the resolution of that issue. If you see the issue, you can seek advice, reflect upon that advice, and act or not act, depending upon the circumstances. And so when I do board trainings for my clients, I do a ton of board training for my clients. When I do board trainings for my clients, it's all about issue recognition. It's not necessarily about the answers themselves. It's about understanding that I see an issue here related to conflict of interest. I see an issue of my objectivity versus subjectivity, and can I be involved in this ultimate decision-making process? So it's due process of law, protects everyone involved, all parties, including the decision makers like yourselves as board members. So now, thinking back about why you became involved with your board, I want you all to write down, and if you want to put it in the chat, you're more than welcome, but write it down on a piece of paper. What's one word that best describes what you bring to the respective physical therapy board? Can you narrow that down to one word? And reflect upon that for a minute and think about it, because this is, again, what makes you tick. This will help identify if you are unbiased or biased, or if you are objective or subjective, however we want to start to phrase this. And the bottom line to all of this is managing these issues. So we've got perspectives, we've got authority that are coming up. And so think about the word you wrote down, and we might put a few of you on the spot, maybe ask you to reveal your word as we approach the end of our session. So it's important, though, because, again, what makes you tick is the technicalities of the law, but we certainly have to layer on top of that the personal issues that you bring to the table. So if I asked you to choose between one or two and didn't tell you why, what would you guys pick? Go ahead and text that in, or chat that in. So we got a couple of houseboats, got a lot of houseboats. Yeah, we've got a speedboat, powerboat, whatever that's called. And so think about this and the reason I put this in here is rush to judgment, which, by the way, in today's day and age, everything seems to be number one. Rush to judgment, or what the issues might be that come up, or another, and I'm phrasing these purposely negatively. One, rush to judgment. Two, inefficiencies of government. You're just charting your course, plodding along, not getting very far very fast. And a lot of people perceive government to be that. And somehow we want to bring these types of issues in. And is this what makes government tick? Is this what makes you as a regulator tick? I don't know. But it's certainly worth thinking about. And I would choose two myself as well, because you're so much less, you're less likely to make an error than if you're cruising along at 100 miles an hour. So just something to think about. Now, chat the number applicable to you. My primary motivation for initially getting involved with the regulation with your board itself was, so this is all the way, think back in the past and say, what was my initial motivation to get involved with my board? Promote the profession, influence the future of the profession, regulate the profession, give back to the profession, achieve fame and fortune, maybe other. And I came up with some ideas that I thought would be important, and there's probably a lot of others that might exist out there. And somebody says all of those, excellent, including the riches. Yeah, fame and fortune, right? So you think about that, and as you're reflecting upon that, we're going to go to the next one, which is my current motivation for staying involved in the regulation of physical therapy is currently, what is it? And I'm giving you the same answers, same options, I should say, as potential answers. So we think about that. Has your perspective changed? Has your mindset changed? Did you receive training and that changed things? Did you receive training at the state level? Did you come to board training for FSBPT? And are there things that are influencing you one way or another? So keep me on time here. So this is the question. If anybody wants to unmute and tell me this, has your view or perspective or knowledge of regulation changed since you first came on the board to today? Some of you are probably veterans, have been around a long time. Some of you may be rookies. But anybody want to unmute and tell us? And I will say the first person that unmutes, FSBPT gives away these great prizes. I think, did we do it last time where they gave away a trip around the world to someone, free flights everywhere?
Yeah, I'll take the bait. Can you hear me? Sure. Okay. This is Jackie Waring. I'm a board member on the Physical Therapy Licensure Board in Utah. And I will say that my perspective has changed really based on some of the trainings that FSBPT has done.
Excellent. And FSBPT, take that to heart, because the role that organizations like them play, like you all play as an organization, as a collective wisdom, is super important. And so thank you for unmuting, and we will send you your prize via the mail. So hold your breath until it gets there. But anybody else? And can I assume that most of you might say yes to this answer? And the reasons it might be different, but yes, it has changed. And I applaud for those of you who are willing to say that, because I would suggest to you, and as I've mentioned, I've done board training almost my entire career for my clients at the state level. And I think that they do change. I think people come into these boards thinking one thing, and then they realize that perhaps that is a role that is reserved for a different group, like trade or something. So think about what influences that change itself. Increase knowledge in others. So someone else who wants to unmute and win another lucky prize. Do you influence the board, or does the board influence you? And I realize that most of you would probably want to say both, but somebody take a stand on this. What do you think? How would you answer this if you had to take one or the other?
Yeah, Mike Clinton, from a public board member from Arizona. I'm a CPA, and my financial background and perspective has influenced the board a great deal.
Excellent. Great example of something that public members can bring to the table, a level of expertise that is not profession driven, but it's operational, board driven, about whatever budgetary issues and reading of financial issues or anything else that might come up. And so, having a CPA as a public member, having a lawyer as a public member, or anything else. And what I have learned to say over the years as well is when, for you board members out there who are licensees, when your term is up, and if you are still wishing to give back to regulation, you can be a public member on a different board. Imagine that if people moved around like that, how much expertise could be brought to the table, because, hey, I might have served my 2-3-year terms. I have 6 years of regulatory experience, and I move over to the let's say medical board. And what I have done in other trainings is to get certain points across. Is if I were the governor and I came in, I might make the medical board the nursing board. I might make the nursing board the chiropractic board. I might make the chiropractic board the medical board. And then everybody gets all nervous. Why? Because they're probably wanting to protect their own turf. And that's how you can get issues to surface about this and what makes regulators tick. So let's keep going here. So in our last few minutes. So managing your personal agendas with that of government and ultimately the board that you're serving on is the bottom line goal here. We know that we all have, again, these personal preconceived notions, but they have to be managed in a manner that protects the process, that provides due process, recognizes the rights of all people involved. And it's not always just individuals. It might be recognizing continuing education providers. It might be recognizing, exam programs or academic programs or anything else. And so we have to assure that we put all those personal, if you will, agendas aside. And I don't say it in a bad way, by the way, but that we put those personal agendas aside and that we ensure that the work that we do. So reasons, what are your reasons for volunteer service? You could make a list super long here if you wanted. I just threw a few in here, including maybe somebody did it on a dare, or you did it to make a little bit of money, which I realize is supposed to be funny. So I hope you guys are laughing out there. And once we consider the personal aspects of this that you bring to the table, you can't forget that this is a group decision-making process. Majority rules, okay? Majority rules. And we've already talked about it. If I'm in the dissenting vote side, what can I do? What should I do? What must I do? And again, it's a recognition of the fact that if a process is followed, everyone had their chance to weigh in. Staff probably brought data to the table, whatever else is done, and the decision is made, and everybody complies with that decision. And it's not always easy, but that's just a group decision-making process. And we need to have groups regulating professions. Otherwise, we end up with upside down pyramids that are driven by too few or too small of a sample of potential, if you will, regulators. So majority rules on that. So back to the original topic now, and we have a few minutes at the end here if anybody has any comments or questions. What makes regulators tick? Your statutes, your rules and regs, your policies, and then over on the right side, of course, your core values, your leadership, your responsibilities, your integrity, your ability to be innovative, and others. All will identify how you operate as an individual in a group decision-making process under the umbrella of these laws that exist and policies that exist. And so I think it's worthwhile to have these kinds of conversations, though in the end, this probably sounds really basic to most all of us. But it's important that we say it out loud. There's so much, I think, importance arises out of saying things out loud about law and what it means, statutes, what they are, regulations, or anything else that you might think is important. Lastly is I encourage each of you to have strategic and generative planning sessions with your boards. Okay, you notice it up, it's open to the public, fine, but that you only have an agenda item dealing with strategic driven issues of how you're going to operate as a board, how you address the legislature, how you can encourage communications without lobbying, anything that you think is important to create these visions so that your board members are all operating under the similar principles. And then lastly is when you develop those, read them into the record at the start of every meeting. Put it in the record, put it in the minutes, make sure everybody understands this is why we're here. And I've already talked about a lot of other issues related to minutes of board meetings in the past, but the point being is that dress up those minutes so that everybody understands that you're on the same page doing the same thing. So any questions or comments that anybody has?
Real quick, Dale, could you clarify something that was said earlier? It sounded like one person suggested that when a board is taking a vote, you could do a roll call so that each individual board member's vote is put in the minutes with respect to that person. Did I hear that right?
Yeah, and I think to me, that's good policy. It's just read through the roll call list and you're either going to say yay or nay, and it's recorded that way so that there's no confusion. Even on what you might think is a mundane issue, I think it's good policy to always do that, do roll call votes on anything that comes before the board. Your boards are small enough. It shouldn't bog down the timing driven issues. Yeah, I think that's what was said, and I think that's probably good policy. Other comments or questions?
Dale, I have a question here for you. What is the best approach when you have a board member who refuses to recuse themselves and their bias is evident? What is the best approach?
That question comes up regularly. And so in our last minute here, I'll try to zip through this. Is the failure to recognize a conflict is a serious issue. And to me, the board chair has to then be a good leader, bring the issue up, and eventually, if you need be, involve counsel, okay? And knowing that you may have to take a vote to actually have someone removed from the board for purposes of this one decision, whatever it might be. And so you can go all the way to that end, but generally, if you put the right kind of discussions, and I'm going to call it pressure on persons, generally they're going to see it, but not always. Not always. And if it's so evident, you have to remember that their activities being in a position of conflict and voting on a matter can create some serious legal issues, let alone political issues that might surface out of that. So I think there are mechanisms to browbeat where necessary, involve counsel, and if you have to ultimately make a motion and take a vote on it. A good chair in leadership with the executive director hopefully can address most of these. That's a great point. That's a question that comes up pretty regularly. And know the difference between recusal and abstention, by the way. So, and Stacy, so we're right here at 4:00. So again, a big public thank you to FSBPT, the board, staff, And the biggest thanks goes to each and every one of you. Stacy, I'll turn it back to you.
Well, thanks, you, Dale, for always being willing to serve in this capacity and giving us some great information to be able to use in our jurisdictions. I appreciate everyone else for joining this afternoon, and hopefully you have a lot that you can share with other members of your boards that will assist them. Please be sure to take the survey that you received for this particular webinar, as well as look forward to joining us either next Wednesday for exploring the challenges of regulating a hands-on profession in a hands-off era on July 28th. Also Thursday, August 5th, Bias in the Mirror. And then the next regulatory hour is Here Comes the Judge, which promises also to be very interesting. Thank you again for sharing your afternoon with us, and I hope to see you all next week.